That's awesome. Okay, so thanks everyone for coming today. We're gonna talk about tenant rights in New Brunswick and knowing your rights and how to take action. So just a quick overview of what we're going to talk about. I'm going to do a quick intro about myself. We're going to talk about key tenancy rights under New Brunswick law. Then we're going to talk about how to navigate the TLRO, or the Tenant Landlord Relations Office. And then the most important part of the slide is a disclaimer at the bottom. So this presentation today contains legal information only and should not be taken as legal advice. Please consult a lawyer if you need legal advice about your particular circumstances. I am not a lawyer, so I cannot give legal advice. So just a little bit about me. My name is Jack Long. I'm originally from St. John, New Brunswick, and I'll be going back to St. John, New Brunswick after graduating this spring. And as I mentioned at the start, I'm a third-year law student at the University of New Brunswick and a student clinician this semester at the UNB Legal Clinic. So tenancy legislation in New Brunswick. So the legislation we're going to talk about today is the Residential Tenancies Act, which I will sometimes reference as the RTA or the Act. The administration that watches over this is the New Brunswick Housing Corporation, and the branch, as I mentioned before, is the TLRO. So there's also a Landlord and Tenant Act, but this deals mainly with commercial leases. It can apply to residential tenancies that do not fall under the RTA, but we're not going to deal with that today because it's usually harder to access. Because an application has to be made before the Court King's Bench and not the TLRO. This is kind of an access to justice issue, but that's out of the scope of today's chat. So the Residential Tenancies Act, who is covered? So tenants who have entered a tenancy agreement with a landlord to rent a premises for residential purposes, including an apartment, a room in a boarding house, a home, or a mobile home. And in these cases, you can be paying the rent completely on your own, or social development can be helping you pay the rent. Now, who is not covered? So if you live in an apartment or house or mobile home and you share a kitchen or bathroom with your landlord, you're not covered. If you live in a certain type of public housing, like owned by Housing New Brunswick, if you live in a building, a business or agricultural premises where the living accommodations are attached and it's under one lease, if your employer provides you with housing, if you're staying at a vacation home or a tourist accommodation, or if you're staying in a dormitory or residence like here at UNB. Other people who are covered, if you're in a nursing home, hospital, this includes psychiatric. If you're in any type of community placement, like special care home, foster home, correctional facilities, rehabilitation centers, covenants and monasteries, emergency shelters, and youth hostels. So again, these tenancy types could be covered under the Landlord and Tenant Act, but as I said, the process is more complicated and it's kind of outside of the scope of what we're talking about today. So the tenancy agreement. If your tenancy is covered under the Act, you can't contract out of this standard form lease. And this tenancy agreement is the starting point in any Res 10 matter. So the standard form lease, or SFL, is maintained and administered by the TLRO and is available on their website for anyone to look at. There's special rules for long-term tenancies, mobile homes, and boarding lodging houses. So quickly, I'm going to try and see if I can pull up this standard form lease. If it doesn't work, I can bring it up at the end. I've got some documents here to show through, but let's see. As you can see, my technological skills are not the strongest for a 24-year-old, but Good. People can see that.
I can see the residential lease standard form of lease.
Great. Yeah, so this is the standard lease that you would see if you go onto the website. So as you can see here, it's just basic landlord tenant, premises, inspection, additions, how long you're going to stay there, the parameters of rent, uh, late payment fees, what the landlord is going to provide in the unit or home, security deposit, assignment, and then signatures. So a completed copy of this or an original has to be in the possession of the landlord and the tenant once it's completed. And at the back of the standard form lease is actually a lot of important information that I'm going to be talking about today. But right on the lease, it kind of talks about what the TLRO does, the obligations of both sides, how to serve the tenant or the landlord in cases of disagreements. So the lease itself actually has a bunch of really useful information on it. If you ever sign one of these, be sure to get an original from your landlord. And a lot of the information of importance is actually right on this. So let me go back to it. And we're back. My screen is just very behind.
We can see the tenancy agreement presentation, slide 8, if that helps.
I wonder if I can still change it. Okay, welcome back. Working. Okay, so standard form. Sorry, guys.
Yeah, my apologies for the technology. It's, yeah.
We're running quite the tech operation over here. Okay, so the RTA sets out key requirements for the standard form lease. So as I mentioned, the landlord has to provide 2 duplicate originals of the standard form lease. If they're electronically signed, if both parties get an identical signed copy, that meets the same requirements. Changes to the standard form lease are void except in certain circumstances. Additions to the standard form lease are allowed if they're mutually agreed upon by both sides. They do not alter any right or duty under the Act or the standard form lease. They appear on both duplicate originals of the standard form lease. And if they appear in a separate attached schedule, and each page must be signed by both parties. If a landlord refuses to provide you with a signed copy of your lease, you can file a complaint to the TLRO, And the officer in this case could allow you as a tenant to pay rent to the TLRO until the landlord complies. And the landlord cannot say that you're not paying your rent in a case where this is the kind of the arrangement with you and the TLRO. So here's two examples of additions to a standard form lease. One that's not allowed, a tenant must give the landlord 24 months notice to terminate the year-to-year lease, because this isn't allowed under the Act of standard form lease. Something that could be allowed is a provision saying the tenant must bring their trash to the garbage bins located at the back of the building. So frequently asked questions about tenancy agreements. Do they have to be in writing? No. An oral agreement can create tenancy, but it's treated as if both parties have signed that standard form lease. What happens when a landlord and a tenant enter into a tenancy agreement that is not the standard form lease? Again, they're deemed to have signed a standard form lease. And if the tenant is in possession of the premises, the method of rental payment that is already occurring can determine the term. And what happens when the tenant stays in a premises after a lease expires? This is called overholding. And if a landlord accepts payment of rent in this circumstance after this expiration, it automatically creates a new tenancy agreement, and the term of this agreement is determined by the method of rental payment. Again, if it's weekly, monthly, yearly. So long-term leases. A landlord can alter a provision in tenancy agreements if it's a longer-term tenancy, which is more than 5 years. But the landlord still has to give 3 months written notice. The alteration still can't conflict with the Act, and the alteration has to be considered reasonable and fair. Rent increases are an exception to this, and the landlord must follow the normal process for a rent increase. So fees that are allowed. Landlords can only be asked to be paid rent, a security deposit, or a reasonable amount for any service to be provided in relation to tenancy. And a landlord can charge a late payment fee, but only in limited and very specific circumstances. And in the graphic to the right, you'll see these circumstances. So the tenant fails to pay the rent when it's due. The lease provides the landlord can charge late payment fees. The rent was paid by check or another negotiable instrument. The landlord incurred an NSF charge from their bank or not suitable funds. And the landlord can prove the NSF charge from their bank.
So that means that they actually have to prove that there was not sufficient funds, right?
Right. Yeah. So here's some fees that aren't allowed. Prepayment of last month's rent. And this is not the same thing as a security deposit. A single rent payment that is more than the regular monthly rent, or security deposit more than the amount permitted. So 1 month's rent for a month-to-month lease is the acceptable limit. And in the case where this is paid to the landlord, they must return the money. So part one of our presentation is going to be on tenancy rights. So as I said, in New Brunswick, the Residential Tenancies Act outlines your rights as a tenant. You can also find this on the standard form lease. So some of your responsibilities as a tenant include paying rent on time, keeping the property clean, reporting any maintenance issues promptly. If you break something, you have to repair it, and make sure any guests you have act properly, and you are responsible for their actions at the end of the day. Now, your rights are you have the right to a habitable home, you have a right to privacy, you have a right to fair treatment, you have a right to return your security deposit at the end of your term, you have a right to proper notice of rent increases, and you have the right to proper notice of termination. So first, right to a habitable home. So landlords must maintain safe and livable conditions. When you visit an apartment or rental unit initially and you notice that there are kind of issues with cleanliness or repairs that have to be done, the landlord must still deliver the premises to the tenant in a good state of cleanliness and repair and fit for habitation. The landlord is also responsible to maintain the premises as such during your stay. So if you end up signing a lease and moving in, the landlord is still required to complete the necessary repairs and address cleanliness issues that were promised. The landlord can't say, well, you accepted the premises as they are. No, they still have the obligation. The landlord can't deliberately cut you off water, heat, or electricity. And yeah, it has to be a habitable spot. So we always recommend, as a rule of thumb, to take pictures or videos on the phone of the premises when you move in, and do the same thing when you move out for security deposit reasons. So right to privacy. So as tenants, you're permitted quiet and peaceful enjoyment of your home. This means that the landlord can't come barging in your apartment or place of living without notifying you in writing, unless it is an emergency or the landlord believes that the premises have been abandoned. So notice for this must be in writing. It must have your name as a tenant, the address of the premises, and must be signed and dated. So if it's a routine repair, the landlord has to give you 7 days notice, unless you specifically requested the repairs. And if it's for viewing purposes to show other prospective tenants, if you're moving out, or inspections, it's 24 hours notice. Unless it's the last month of your lease, then it can be sooner. And if the written notice doesn't comply with the requirements that I mentioned, it will be declared an invalid notice. To carry out repairs and maintenance requested by you in writing, the landlord can enter at any time within 2 working days. So this means Monday to Saturday between 8 a.m. to 8 p.m. of receiving the request. If it's been longer than that since you made the request, they need to give you at least 24 hours notice. So right to fair treatment. You're protected against discrimination of all levels as a tenant during the rental process. And this is when you're viewing, when you're signing a lease, when you move in, when you're living in it, and when you're leaving. So examples of right to fair treatment: a landlord cannot refuse to rent to you because you have children, you're a student, you're on income assistance because of your race, religion, gender, or sexual orientation. A landlord can't evict you for any of these reasons. And a landlord cannot charge you more rent or fees for any of these reasons. So right to return a security deposit. When you move into a premises, a landlord can ask that you pay a security deposit equal to a maximum of 1 month's rent to cover potential damages or unpaid rent when you eventually leave the premises. So security deposits can be paid directly to Service NB, and you have the right to request that your security deposit be returned to you when you move out. You can make this request within 7 days of terminating the lease to get your security deposit back, but the landlord can make a claim if there's damages or unpaid fees to be deducted. So you will be notified by the TLRO if there's a claim against your security deposit. The landlord also has 7 days to make such a claim, and you'll have a chance to dispute the claim. So that's kind of why I mentioned it's important to take pictures and videos before and after to show the state and make sure you didn't do any damage. So the landlord might say that you damaged the appliance or the floor of the walls, when what actually happened, it can be classified as normal wear and tear, which is something you can use as a defense. So the security deposit forms they're seen there. You can find all these forms. I'm going to show you on the website. I'm not going to go back and forth because of that technological situation. But yeah, they're all available online. The Housing NB website's a really useful resource. They have a lot of information on there, all these forms, and I would really recommend going to check out that website. So you have the right to proper notice for rent increases. So landlords must also provide written notice before they can increase rent. Landlord must give 6 months notice for rent increases. The notice is in writing. It's got to be in a separate document. It can't be on a monthly receipt or notice that includes something else to try and kind of hide it. The rent cannot be increased in the first year of your tenancy as well, or more than once per year following the first year of your tenancy agreement. So the content of the notice of rent increase. So as I said, it's got to be in writing on a separate document. It has to address the name of the tenant, the address of the premises, that's subject to the rent increase, and the current amount of rent payable after the increase takes effect, and the effective date of the increase. The notice must be signed and dated by the landlord or an agent. So the right to proper notice for rent increase. So the tenants can ask for a review of the increase for the TLRO. This has to be within 60 days of receiving the notice to increase rent. The landlord cannot raise rent or retaliate against you for making a complaint or any other reason, but there's a shorter window to request assistance from the TLRO, and that's 15 days.
And that's if the rent increase is in retaliation,
Right.
right?
So the 15 days only applies to a rent increase that's in retaliation. Whereas any other normal increase, you have 60 days, which is a lot more time. So there's new changes that are effective February 1st, 2025, where the TLRO can ask the landlord to show that notice was given on a separate document served on the tenant. If the tenant cannot prove this, then the notice of increase is set aside. And if the landlord can prove this, the rent increase will be confirmed. This is effective, as I said, February 1st, 2025. Before this, the landlord was required to establish that the increase in rent was reasonable in relation to that charge to comparable units in the same geographical area. Potential issue in this is in smaller towns like Fredericton could be considered. Landlords can own the majority of rental units, so they can kind of conspire to increase rents together. So these new changes are supposed to hopefully combat that a bit. So continuing on the same topic, if the landlord provides the proper notice in writing and the tenant does not want to stay in the premises, they can treat the notice as a notice of termination. And this takes effect on the day prior to the date that they listed the increase will take effect. In this circumstance, the tenant must notify the landlord in writing, include the address and date, and sign themselves. So also effective February 1st, 2025, there's a new rent cap of 3%. Landlords can still request an exemption, but they must prove capital expenditures have been incurred, and the absolute max is 9%. There's going to be an annual review of rent cap by the New Brunswick Housing Corporation, and they have to consider, among other things, inflation, rental market surveys by CMHC, vacancy rates, and this review will be published on June 1st of every year. So watch out for that. So assignment and subletting. So assignment is when you as a tenant have someone else take over your lease if you cannot stay in your unit. A lease can't prohibit assignment or require landlord's consent, but it can't be unreasonably withheld. Now, assigning assumes all of the tenant's obligations during the period assigned, and the former tenant cannot be sued for obligations arising following the assignment, but often new leases are signed. A sublet is when a tenant rents the premises to a third party. So examples, finding someone to stay in your unit while you're temporarily away. So I know a lot of students do this when they go home for the summer and stuff like that. So in this case, the tenant on the lease remains responsible to ensure that the rent and all the obligations are carried out, and the tenant usually moves back in at some point. So if you're in a sublet situation, be sure to kind of vet the person that's going to be staying at your place, because you're going to be on the hook for any issues they cause. So transfer of a rental property by the landlord. So if your landlord sells or transfers your property, the tenancy automatically goes with it. But the landlord must notify the TLRO and you as the tenant within 7 days of the transfer. The transferee becomes a landlord under the existing lease, and a new landlord cannot force a tenant to sign a new lease or end the lease early. You're still under that same standard form lease you signed initially. Yeah. So what's considered an emergency? So the term emergency is used throughout the RTA, but it's not specifically defined. The website itself provides some guidance, but it's not an exhaustive list. And special rules apply in this context, as I mentioned earlier. So on the website, it mentions things like fire, floods, active destruction, leaks in pipes, disconnection or issues with electrical, damage to defective locks, threat of eviction by a landlord, especially if kids are involved. And obviously, if you need immediate assistance, call 911, as it says there. So you have the right to proper notice for termination. So a tenant must give the following notice periods to the landlord when wanting to end a tenancy. So if it's a year-to-year tenancy, it has to be 3 months. If it's month-to-month, it's 1 month. And if it's week-to-week, it's 1 week. Now, if you're in a fixed term arrangement, no notice is required, and it ends on the last day of the term. You can't really get out of it. And there's strict requirements for contents of the notice. And there's the notice there. So each party has a different type of form they fill out. So terminating a tenancy as a tenant. So a tenant may want to terminate their lease in specific circumstances. Maybe it's domestic violence. Certain evidence is required for this. And just in general, a continuation of tenancy would cause extreme hardship to the tenant because of health issues. Again, you have to provide evidence of this, but these are reasons where a tenant can terminate before those kind of timelines I mentioned. So a request to end lease early by you as the tenant. So first, I'd always recommend you discuss it with the landlord. You never know, maybe they'll agree, maybe they have a list of people waiting to get in the building. So maybe it can be easily facilitated. This can be considered a breach of contract, and that's why it'd be nice to figure this out amicably. If they do not agree and you decide to leave, they will most likely keep the damage or the security deposit. And they can potentially sue in small claims for balance of the rent until the end of the tenancy in months. So they do, as landlords, have a duty to try and rent the place, or they will have a tough time in front of an adjudicator to justify their position. There's very low vacancy rates in the province, so it'd be tough to argue for an extended period of time that they couldn't find someone to move into the unit. So they do have a duty to kind of cover their own butts, but you can be on the top. So termination by the landlord. So the landlord can only terminate tenancy for non-payment of rent, or if the tenancy does not, or the tenant does not continuously comply with its obligations. Otherwise, in very limited situations. So these situations are if the landlord intends in good faith to have his spouse, children, parents, or in-laws move into the premises for at least 3 consecutive months. If the landlord wants to change the use of the premises to something non-residential for at least 3 months. And if you're the building superintendent and part of the lease conditions include free rent and you stop working for the landlord. So a landlord must give reasons and the tenant can apply to the TLRO within 15 days to investigate. TLRO investigation can set aside or modify the notice, but if a tenant does not apply within 15 days, they will have been deemed to accept this termination. So if the landlord does not actually occupy or convert the premises as set out in the notice of termination for the reasons I just stated, you as a tenant can apply to TLRO within a 2-year time frame for compensation. The landlord must seek approval from the TLRO if a termination for a tenancy is for renovations or repairs. So in this case, the TLRO will already do their due diligence. So in this case, it's after 3 months, the tenant, if you kind of realize that the landlord did not fulfill their obligations of what the reason they kicked you out, if it's a family member moving in, they're changing what the premises is used for. You can file a complaint with the TLRO, and could in theory ask what the moving costs, the increase in rent for a new place, be reimbursed by the landlord in any sort of claim. In practice, though, in reality, people don't usually bother once they're out because they're gone and you can't get your tenancy reinstated. So for the most part, it's not a battle worth fighting, but this is something you can do. So termination tenancy for non-payment of rent. So if you don't pay your rent on the date it's due, the landlord can serve on you a notice to vacate. So there's two different steps. There's a notice to vacate, and this can be canceled if the rent is paid within 7 days of receiving this. And if it ever happens again, there's the final notice to vacate, and that terminates the tenancy, even if the tenant pays the late rent within 7 days. So the landlord must use the right form or it's void because there's two separate forms. And if proper notice is given, the tenant is responsible for rental arrears and any rent to the end of the week or month, depending on what kind of tenancy it is. So if you as a tenant have ever failed to pay rent, subsequent payment of rent does nothing if the landlord notifies the tenant as required under the Act. Now, there's two different forms. There's the notice to vacate, which is the one on the left of the screen, and the final notice to vacate on the right. And the biggest difference with this is the final notice to vacate specifically states in the middle there in bold. I don't know if you'll be able to see it or not, but it says payment of total rent owed does not cancel this notice. So when you get to this point, it's kind of too late, even if you try and pay at the last minute. So now we're going to talk about navigating the TLRO. So New Brunswick Housing Corporation is responsible for the administration of the RTA, and it does this through the TLRO. It's not a tribunal as you might imagine. You don't appear before them, but they do have broad powers to perform investigations, receive your complaints, they can mediate disputes, and they do render binding decisions. So failure to comply with the obligations. So from the landlord side, they must serve written notice on the tenant. If the tenant fails to comply, the landlord will advise the TLRO. The TLRO will investigate, and then the TLRO themselves can serve notice to quit, terminating the tenancy. Something important to note is the landlord themselves cannot evict you. Only the TLRO can evict you. From the tenant side, written notice must be served on the landlord. If the landlord fails to comply, the tenant advises the TLRO. The TLRO investigates, and the TLRO can then perform the landlord's obligations and or terminate the tenancy. So if your issue is a broken window and your landlord just won't fix it, you can go to the TLRO and they have the power to do the obligation of the landlord, which would be fixing the window. And then they will charge the landlord themselves so that they can take matters into their own hands. Or get you out of your lease if that's what you want. So the TLRO themselves outlines the steps. So again, it's always a good idea to talk it over. Sometimes over email or text, it's hard to get a read on people. Sometimes you just have to sit down with someone and you can work it out. After this, you should make your complaint in writing. If the complaint isn't answered to, then you apply for assistance. And that's when the TLRO can have mediation and then render a final decision. And then again, no special rules apply in the context of emergencies, which we went over earlier. So if the landlord's not complying with his obligations, the tenant can submit a notice of complaint. If they don't answer to this notice of complaint, then you can ask for assistance from the TLRO. So as I said, if you ask the landlord to fix a window, roof, stove, and they don't comply, you must serve this notice of complaint to the landlord first. If the method of service is in person, the landlord has 7 days to comply. And if the method is by mail, they must add 3 days. So 10 days in total. At which point the other party will be deemed served. The items to be included in the notice are very specific. So I'll always recommend using the forms that you can find on the TLRO website. And again, you can't just jump the queue and go directly to the TLRO. Unfortunately, sometimes you do have to file this notice of complaint first.
Unless it's an emergency.
Unless it's an emergency, yes, of course. Yeah. So there, yeah. So if the landlord does not comply after 7 days, then you ask for the application assistance from the TLRO. And that form right there, you can find on the website. So you can fill out the form online, and you can send it by email. Always include your lease if you can, receipts, paper evidence, screenshots, text messages, and send it right to their email, which is irent@snb.ca. That's something you can find online as well on their website. If you're going to use an online form, wait for the confirmation number, and then you will have to send an email with all your evidence and include the confirmation number in your email. So what can a TLRO do? So they can order the landlord to comply with what you're requesting. They can order the tenant pay rent directly to them until the landlord complies. They can order that the tenant pay the rent to the TLRO, and then, as I mentioned, they can use the money themselves to pay for the repairs. They can end the tenancy themselves upon application of the tenant. The landlord still won't make the repairs. The application must be served to the landlord. And they can also order the landlord to pay compensation to the tenant, up to 1 month's rent to compensate for costs and expenses of the tenant. So your obligations as a tenant. So the landlord can also fill out a notice of complaint for a tenant if they're not complying with their obligation on the lease. They don't have to use a form, but the content must be the same as on the form. And if a tenant fails to comply immediately or within 7 days, if it's not urgent, the landlord can fill out a request for assistance from the TLRO. It's a different form from the form you guys would fill out. The landlord can also contact the TLRO through a portal for landlords, and the TLRO can investigate. So it's kind of the same process, just a bit different. So your obligation as a tenant, if the tenant does not comply to the satisfaction of the TLRO, the officer can issue and serve a notice to quit on the tenant if this is something the landlord requests. And if a tenant has damaged premises extensively, the landlord could request that the TLRO issue a notice to quit without a notice period. This is obviously discretion of the TLRO, but this would be an immediate eviction. So those are the forms that the landlord would fill out. Evictions. So a landlord can serve a notice to terminate tenancy on a tenant, but cannot evict a tenant. So as I mentioned, an eviction can only be issued by the TLRO. So if your landlord tells you you're evicted, make sure you're not, you're just not. You have to wait till the TLRO evicts you themselves. If a tenant refuses to leave after the landlord's properly obtained notice to quit, the landlord can request eviction from the TLRO without further notice to tenant. If a tenant refuses to leave or overholds when a proper notice of termination has been filed, the landlord can request an eviction, but the TLRO again must investigate first. And the sheriff can forcibly remove tenants if it gets to that point. So there's an eviction order. Hopefully none of you have ever seen one of those. So your property on eviction. So generally, a landlord cannot hold your chattels for default in payment of rents, or they can't just throw them to the curb. If you leave chattels on the premises after you leave, there are specific rules on how the landlord has to handle these. This involves application to the TLRO. They could be required to store them, eventually allowed to dispose them or even sell them. And this is all very dependent on the circumstances. Yeah, so chattels is property. that isn't kind of stuck into the ground. So this is your couches, your knickknacks, and whatever you got in there. So challenging or appealing a decision. So a landlord or tenant can appeal nearly any decision, order, notice, termination, quit, eviction, order to comply that an RTO officer makes. So you'd file this application under section 27(1), and that states the operation of the decision pending the judge's eventual determination.
Stay, explain stays.
Yeah, so a stay just, it's kind of like a freeze. So if you're ordered, if it's an eviction order and it's stayed, you can hang out until the judge decides. So options for the review of a residential tenancies act decision. It can be practically challenging for a tenant. It's a fairly strenuous process, as the appeals are heard by the Court of King's Bench, which is very backed up, and it won't be a quick decision. It won't be a cheap decision. And you only have 7 days to file your application. So that turnaround is very, very quick. And a lot of people would miss that. So with that, I want to thank you all for attending today. I'm sorry about the technical issues. If you have any questions, feel free to contact the UNB Legal Clinic. That's our information there. You can find us online. And yes, as mentioned, I'm happy to take questions. And if you have any questions, throw up your hand again. I can't provide legal advice, but me and Jeanette can try our best to answer any queries you have. Let's see if I can stop sharing here.